The Supreme Court is trying to decide a landmark case on affirmative action. Should race continue to play a role in how colleges pick their students? The answer could affect college admission for millions of Americans for generations to come. Joining us from Washington is Amy Howe, editor for ScotusBlog. Amy, good morning to you.
Good morning.
This case was brought on by a white student. She says that the University of Texas denied her admission based on her race. What are both sides of the argument here?
There are two sides of the argument. So she says that she was denied admission based on her race, and that is unconstitutional because minority students with less impressive credentials than hers were admitted. And so she is in court because the University of Texas admits students in two ways. One is through what they call a top 10% plan, in which every student who finishes in the top 10% of her class in Texas is automatically admitted. But she wasn't admitted in that way, and she was trying to get one of the remaining slots at the university, and which does consider race. And so the university says she wouldn't have been admitted at all. She's saying that the university doesn't need to consider race in admission at all because it already has a diverse undergraduate class using the top 10% plan. The university's argument is that it isn't diverse enough using the top 10% plan, that it needs more diversity and that it needs to be able to consider race until it reaches what's called a critical mass of minority students.
9 years now since affirmative action has been in front of the Supreme Court. Back then it was Justice O'Connor who wrote the majority opinion. She's now retired. Why bring up these policies now? Why are they back in front of the court and in question?
They are back in front of the court in question, as you suggest, in no small part because the court has changed. Justice O'Connor has been replaced by Justice Alito, who's significantly more conservative than she was. And so the opponents of affirmative action, I think, really wanted to try and get this case up in front of the court to see, at a minimum, if they could convince at least 5 justices on the court that the university goes too far, that this policy isn't consistent even with the court's opinion 9 years ago. And they also, I think, really wanted to try and see if they could get the new 5 more conservative justices on the court to overrule Grutter altogether.
Besides this being a more conservative court, is there a major difference? Any other differences between the 2003 case and the case that's in front of the court right now?
I think that depends on your perspective. The Abigail Fisher's argument is that there is a big difference because the University of Texas already had a very diverse undergraduate class using the top 10% plan, and that this is really just trying to gild the lily, and that it doesn't need to do so. And so, bizarrely enough, one of Fisher's arguments is that they don't really need to consider race in admissions because it adds so few minority students to its undergraduate class. She's saying the University of Texas is already diverse enough. So the response to that is that this is really just like the court's decision in Grutter. They're considering race as one factor among many to figure out whether or not some of these students should be admitted. And they say that the court said in Grutter, you can do this until you reach a critical mass of minority students, and we're not there yet.
I know, Amy, that you were actually inside of the court today. Did you get any impression from the justices based on the arguments that you heard?
Yes, the justices, for the most part, were fairly easy to read. And we saw in the healthcare cases that the oral arguments certainly are not always perfect predictors of how the case is going to turn out. But Justice Elena Kagan was recused, so that left the 3 more liberal justices, Ginsburg, Breyer, and Sotomayor. And you certainly had the sense that they would vote to uphold the university's policy. Justice Clarence Thomas did not ask any questions, but the remaining more conservative justices, the Chief Justice, Justice Alito, Justice Kennedy, and Justice Scalia, all seemed fairly hostile to the university's arguments.
Let's talk about the end result here. So we skip to the end. What's likely going to happen here? Do we see affirmative action struck down altogether or at least scaled back?
I don't think the court is going to come out, whenever it issues its decision and say, we're going to strike down affirmative action altogether. It would, be a huge overruling of its decision in Grutter just 9 years ago. And the lawyer for the university, Greg Garr, and the Solicitor General of the United States, Don Verrilli, both repeatedly emphasized to the court that Fisher and her lawyers were not in this argument asking the court to overrule Grutter and get rid of affirmative action. It does seem very likely, though, that the Texas plan may not pass muster and that the court is going to set some limits on when universities can consider race and how they can do so.
It's always unpredictable. We'll see what happens. Amy Howe, editor for ScotusBlog. Amy, thank you so much.
Thanks for inviting me.